Apologies, I was
No,
not able
no,
held up
he
in
was
quota number
not.
6.
That's all right.
Well, basically, the offense that is alleged is 1 under section 307,
Attempt to murder.
attempt to murder.
Mm.
Well, how the courts have said, my lord, with regard to the attemptees, but for some intervening cause,
302 ಆಗ್ತಾ ಇದೆ.
had the act been completed, ಅದು 300.
302.
ಅಲ್ಲ, ಇಲ್ಲೂ ಅಷ್ಟೇ 307 ಆಗ್ಬೇಕಾದ್ರೆ ಬಟ್ ಫಾರ್ ಸಮ್ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಕಾಸ್ ಹ್ಯಾಡ್ ದ ಆಕ್ಟ್ ಬಿನ್ ಕಂಪ್ಲೀಟೆಡ್. ಇಲ್ಲಿ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಕಾಸು ಇಲ್ಲ, ಆಕ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ. ಐ ಆಮ್ ಶೂರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವುಡ್ ಸರ್ಟನ್ಲಿ ಅಗ್ರಿ ವಿತ್ ಮೀ. ಅಟೆಂಪ್ಟ್ ಇಸ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ಪ್ರಿಪರೇಷನ್. ಪ್ರಿಪರೇಷನ್ ಡಸ್ ನಾಟ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ an act of attempt. Illi. What is 307 according to them? Attempt to commit murder. How? In what way I did it? There must be a basic minimum allegation for the court to have noticed the commission of a cognizable offense for the purpose of making an order of reference under section 156(3). No. Exchange of messages. Kindly proceed with an assumption for the sake of argument, do not considering for a moment at this point of time that there are certain exchange of messages. Subsequent to the exchange of messages, there must be some act.
So it remained at messages only.
ಅಷ್ಟೇ ಮೆಲಡ್,
Only.
ಅಷ್ಟೇ ಮೆಲಡ್. I don't know how your lordship would recall to your lordship's memory under the provisions of the Essential Commodities Act under section 3 and 7.
7.
The state government would issue certain notifications
Notification under 7.
prohibiting interstate or interdistrict movement of
Prohibiting
goods
many
and all
things
that.
under 7.
Many, yes.
Which becomes an offense under section 3.
Well, supposing I load the food grain into the lorry, it does not constitute an offense. It is only a preparation. In the last minute, my lord, I may realize, look here, what I am doing is incorrect. I will unload it. Then it will not constitute an offense at all. It is not an attempt. It is only a preparation. Now, attempt for what? Black magic is for what? To see that she is subjected to some kind of torture or harassment.
That is why, if I may say, 399 and 402 are differently worded.
ಅಲ್ವೇ
Preparation and attempt.
ಅಲ್ವೇ ಇನ್ನೊಂದ್ಸರಿ ನೋಡೋಣ ಇದರಲ್ಲಿ. My learned friend my lord invited my lord's kind attention to schedule class 3 ಅಲ್ವಾ? Schedule 3 ನೋಡೋಣ ಒಂದ್ಸರಿ.
Whoever attempts.
ಅಲ್ಲ no my lord. No.
Schedule of the act.
Schedule.
No.
Constitution office.
No. ಇದರಲ್ಲಿ ghost
Under the pretext.
ದೆವ್ವ. I don't know. Probably in Gudiyaman, my learned friend might have invited my lord's
Under
attention. Under the pretext of
expelling the ghost, assaulting by tying the person.
Assaulting by tying the person with a rope or chain, beating by stick or whip to make the person drink footwear, soaked water, giving chili smoke, hanging a person to roof, fixing the roof.
Under Milord, under provision
Or
2.
by hair or pluck his hair, causing, what is all
That
this?
different Milord, because what happens Milord, schedule has Milord item number 1 to 16.
ಇಲ್ಲ, ಮುಂದೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ.
ಮುಂದಕ್ಕೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ.
ಅಲ್ಲ, ಓದೋಕ್ಕಿಲ್ಲ.
ಇಲ್ಲ, ಯಾವ್ದಾಗಲ್ಲ. If at all, my lord, at the worst, if we take the entire my lord allegation to its face value as true, it should come within the parameters of 1, 2 and 3.
Please.
Beyond it ಬರೋದಿಲ್ಲ. I'm sure my learned friend would certainly fairly
ಆಮೇಲೆ
concede.
ಬೇರೆನೇ ಇದೆ.
ಬರೋದಿಲ್ಲ, ಯಾವ್ದು ಬರೋದಿಲ್ಲ.
Practice.
ಒಂದ್ ನೋಡೋಣ performing completion. Inhuman evil act and black magic in such of precious things to create an impression by declaring that a power inapprehensible by senses has influenced one's body, or that a person has possessed such power, thereby create fear in the minds of others, or to threaten others of evil consequences for not following the advice of such person, or deceive, defraud and deter him. ಎಲ್ಲಿಗೆ ಬರ್ತಿದ್ದು? ಏನ್ ಮಾಡಿದೆ ಅಂತ 1, 2, 3 ಬರೋದಿಲ್ಲ, ಬಾಕಿದ್ರಷ್ಟು ಇಲ್ವೇ ಇಲ್ಲ.
ಬಾಕಿದವರು
ಬರೋದಿಲ್ಲ. ಇದು ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ, ಇದು ಯಾವ್ದಾದ್ರು 1, 2, 3 ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ ಆವಾಗ 307 ಆಗ್ತಾ ಇತ್ತೋ ಏನೋ, ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ 307 ಏನು? Milord, what the Supreme Court has said is, we have a common notion that under section 468 of the CRPC, Milord, the prohibition is imposed only upon the court. No court shall take cognizance of an offense excepting upon a complaint filed within a period of so and so.
after the limitation.
ಅಲ್ಲಿಗೆ they can't contend that it is a case there is a prohibition imposed upon the court from taking cognizance. Even a prohibition is imposed upon the policeman from taking the complaint is a law laid down by the Supreme Court.
No. That should not be mistaken. Cognizance can be taken after 10 years.
ಮಾಡ್ಬೋದು.
It is the act of the complainant to file a complaint within
ಇಲ್ಲಿ
limitation.
what is
That
Supreme
is not the law is that cognizance ತಗೊಳಕಲ್ಲ.
ಅಲ್ವೇ?
Complaint
Yes.
ಮಾಡಕ್ಕೆ 3
Complaint
years ಒಳಗೆ
filed
ಮಾಡಿರ್ಬೇಕು.
within a period. Well, what the Supreme Court has said is, even when you go before the police, you should be well within time.
Yes.
The period that is prescribed is what the Supreme Court has said.
The complaint is entertained. The court at its own ease takes cognizance after 7 years. That would not absolve the
ಅಲ್ವೇ?
accused.
ಅಲ್ವೇ?
It is only the
The policeman
victim.
ought not to have registered the crime at all. Well, that is what the
clear.
Supreme Court has said.
ತಾರಾ ಮ್ಯಾಥ್ಯೂ ಅಲ್ಲಿ ಹೇಳಿರೋದೇ ಅದು.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಭರತ್ ದಾಮೋದರ್ ಕಾಳೆ ಕೇಸ್ನಲ್ಲಿ this is what the Supreme Court would say in paragraph 10.
No, the constitution bench in Sarah Matthew has clarified this, saying that it is not, limitation does not run on the date on which the court takes cognizance, but
The date
on
of
the
filing
date
of
on
the
which the
complaint.
complainant registers the
ಅಲ್ವೇ?
complaint.
ಅಲ್ವೇ?
Cognizance ಗೂ 468 ಗೂ ಸಂಬಂಧನೇ ಇಲ್ಲ.
Otherwise, my lord, everybody would contend for no fault or sin on my part on account of some laches negligence on the part of the court. Why should I be
That is
thrown?
true. No, that is
thrown
why
out?
Supreme Court has clarified. Cognizance has nothing to do with limitation.
My lord, just to
Yes,
refresh
yes.
my lord's memory, I shall read this only 1, 2 or 3 sentences from this paragraph 10, my lord. On facts of this case and based on the arguments advanced before us, we consider it appropriate to decide the question whether the provisions of chapter 36 of the code apply to the delay in instituting the prosecution or to the delay in taking cognizance, as my lord has pointed out. As noted above, according to the learned counsel for the appellants, the limitation prescribed under the above chapter, that is 468, 469, 470, 471 and onwards, chapter applies to taking cognizance by the court concerned. Therefore, even if a complaint is filed within the period of limitation mentioned in the said chapter of the court, if the cognizance is not taken within the period of limitation, the same gets barred by limitation. This argument, my lord, seems to be inspired by chapter of the heading in chapter 36 of the code, which reads thus: limitation for taking cognizance of certain offences. It is primarily based on the above language of the heading of the chapter.
No, that is, I have not prescribed to that at all till now.
The argument addressed on behalf of the appellants that the limitation prescribed by the said chapter applies to taking of cognizance and not filing of the complaint or initiation of the prosecution. We cannot certainly accept such argument because a cumulative reading of various provisions of said chapter clearly indicates that the limitation prescribed therein is only for the filing of the complaint or the initiation of the prosecution and not for taking cognizance, as my lord has pointed out.
There is a judgment of the coordinate bench which says cognizance runs limitation.
ಇಲ್ಲಿ
Cognizance will ಎಷ್ಟೋ ಸರಿ ಇಲ್ಲ, magistrates will not have taken cognizance for 10 years.
ಬಿದ್ದಿರ್ತಾರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫಾರ್ ಒನ್ ರೀಸನ್ ಆರ್ ದೇ
ಮತ್ತೆ ಆಲ್ರೆಡಿ ಇದೆ.
ಇದನ್ನ ಆನ್ಸರ್ ಮಾಡಿಲ್ಲ ಇದನ್ನು.
It should be the first judgment.
First judgment. ಅದಕ್ಕೋಸ್ಕರ my lord, I may win, I may lose. That is not the issue. If my lord were to lay down the law, my lord, that would be of some use for future litigations.
Yes. Unless I am hit by blackmail. Yes. Heard the learned counsel so and so and learned senior counsel C.V. Nagesh appearing for the respondents. All 3 matters reserved.
Please,
Yes.
oblige.
Interim order in my
Interim
case.
order subsisting in any of these cases in the form that it is subsisting continues till the disposal of the petition.
Please. Sorry, my lord. Because I
No problem, sir. ನಿಮ್ಮನ್ನ ಕೇಳಿದ್ನಲ್ಲ ಅವತ್ತು, ಅದಕ್ಕೆ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೆ.
ಅದು ಅಲ್ಲಿ ಈ ಪಾಲಿಟಿಷಿಯನ್ಸ್
ನೀವು ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವರು ಅಲ್ಲೇ ಇದ್ರೇನು? ಸರಿ.
ಹೌದು, ಇಬ್ರು ಅಲ್ಲೇ ಇದ್ವಿ.
ಅದೇ.
I was relieved by 425.
Yes, sir.